Good.
Morning, Mr. Campbell. We had talked to Ms. Watson with the charges and so forth. Are you ready to proceed?
Please and thank you. Ms. Watson respectfully answers not guilty plea, waives formal reading, and then just would be interested in discussing release conditions.
Okay, not guilty plea is received. Ms. Watson, I'm going to set 2 future court dates, ma'am. The first is what is called an attorney pretrial date. That is going to be just for your attorney, Mr. Campbell. That is going to be on the 10th of December, 2025. It's not a required court date for you. Your next mandatory court date, ma'am, is going to be on January 15th, 2026. That's going to be at 10 a.m. You can be in person that day or on Zoom, but you do need to be present. I do have the city attorney, Mr. Busby, with us on Zoom. Mr. Busby, go ahead regarding a city's position on release.
Your Honor, the city is recommending ROR. We are requesting a condition of no alcohol or non-prescribed drugs. Reports indicate that alcohol was a significant component to this. The victim has not requested a no contact order, but indicated that the parties are working on sobriety together. And so on that basis, for the city to feel comfortable not requesting an NCO, we are requesting a condition of no alcohol or non-prescribed drugs.
Mr. Campbell?
Your Honor, the client and I discussed that. I'm not admitting that she was intoxicated to say it anyway, but there's no objection to the no alcohol or non-prescribed drugs release condition. The client and I have gone over that in detail, anticipating it being entered by Your Honor.
You know how old the children are? Can you tell me how old your children are?
My oldest is 3 and my youngest is 9 months.
Okay. So what I would say is there's nothing that me putting this robe on makes me somehow magically understand about your life whatsoever, your circumstances, anything like that. The thing that I am always want people to understand, the two of you might be absolutely fine now. You've sobered up. The 3-year-old in particular, had you, it sounds like, leaving with the 3-year-old in the middle of the night, you guys engaging in allegedly some sort of conduct with the 9-month-old in bed with your partner, you might be fine with it. You might have moved on. You might be able to laugh it off and say, oh gosh, that was a heck of an evening we all had. That 3-year-old is forming memories and forming relationship bonds. And to see the two most important person in that 3-year-old's life in physical altercation in their home, in their safe spot, is highly traumatizing. So what I would suggest is, even if the two of you are working on your sobriety, taking some steps with that 3-year-old to let them know that their parental units are not going to engage in this kind of conduct again. And that kind of interaction between people that love each other is not okay, is not something that's going to happen in their future, because as adults, you need to consider your kids and you need to consider the safety of your children. And what took place is not okay. Not by any stretch of the imagination. Whether it was seeing mom get arrested and put in handcuffs and taken away by the police, or whatever else. So I would suggest to you that I would turn your focus towards the 3-year-old in particular, whether it be counseling or something else, because again, these patterns of behavior repeat themselves. There may be something like this in your background, I don't know. There may be something like this in your partner's background, I don't know. But trust me, it comes back around. So please consider those things during the time of your release. I will agree with the parties. You're to violate no laws, you're to appear at all mandatory court dates, you're to notify the court of any change of address or phone number, you're not to consume or possess any alcohol, non-prescribed drugs. Clearly, that is something that is not working right now for either of you. I'll release you on your recognizance. I've assigned future court dates. Stay in touch with Mr. Campbell. There'll be paperwork at the desk by the door. Thank you.
Yaman.
All right, Mr. Yaman, can I have you state your name and date of birth, please, for the record?
Scott Yaman, January 4th, 1969.
Looks like you are entering 3 pleas to 3 different domestic violence no contact order violations. Is that your understanding today?
Yes,
Have you had plenty of time to talk to Mr. Campbell?
yes,
Need any additional time?
I do not.
You are 56 years old and you've completed 20 years of education. Is that correct?
Yes,
Are you able to read and understand the English language?
yes,
Entering pleas today to the 3 domestic violence no contact order violations, you are giving up some important rights that we're going to review on the record. These rights apply to each one of your cases. You have the right to a speedy and public trial by an impartial jury in the county where the crime is alleged to have been committed. You have the right to remain silent before and during trial and the right to refuse to testify against yourself. You have the right at trial to hear and question the witnesses who testify against you. You have the right at trial to testify and have witnesses testify for you. And the witnesses can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty. And you have the right to appeal a finding of guilt after trial. You understand those rights, Mr. Yaman?
yes,
Understand that in pleading guilty today, you're waiving or giving up those rights.
yes,
Each of the 3 charges are gross misdemeanors. They're each subject to 364 days in jail and a $5,000 fine. There is a pretrial agreement that I'm holding up, sir. Do you understand the court does not have to follow anyone's recommendation as to sentence, but can sentence you up to the maximum authorized by law?
yes,
Court can place you on probation for 5 years, during which time you pay cost, fees, and assessments as authorized by law. There are some portions of your plea paperwork that have been marked. There's a portion that talks about violating a domestic violence protection order has a mandatory fee of $15. You understand that is not subject to waiver and something the court has to impose.
yes,
Also, conviction for domestic violence charge prevents your ability to both own and possess firearms both now and in the future. Again, do you understand that that is a mandatory condition of the court?
yes,
To the charge of domestic violence no contact order violations, there was 3 total taking place on September 24th, 2024 in the city of Richfield, Washington. How do you plead to those 3 violations?
guilty.
Has anyone made any threats or promises to you to get you to plead guilty?
No,
Are you entering the pleas freely and voluntarily?
yes,
Factual basis states as follows. On or about September 24th, 2024 in the city of Richfield, Washington, in 3 separate and distinct acts, I did contact Pilar Yemen, my wife. Can't read your handwriting. Something with text or phone call, directly via text or phone call, in violation of the restraint provisions of a validly served no contact order. Is that
Sorry,
correct?
that's correct.
Mr. Yemen, is that a correct factual statement?
yes,
Accept the pleas. I'll find them knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. Go ahead, Mr. Campbell.
Your Honor, this is a situation where Scott understands he had a potential diminished capacity offense in relation to these charges. He had some charges over in Oregon as well. He's taken responsibility for. He was in a mental health crisis surrounding also some very significant medical events. That doesn't take away from the impact that happened to the victim in this case. I mean, I think it was a substantial event. Pilar, I think he and the victim, his wife, have been navigating a divorce action. I looked in Ogen today. That action is nearly finalized. It looks like there's just a kind of last bit of work that needs to be done to enter the final orders. So I haven't been able to find filed orders signed by the victim that substantiate this, but I'm very confident that what my client tells me is correct. He's been in an inpatient mental health facility for almost a year. He's asking jointly between the proposal from the city and himself for getting 30 days of credit for time served for that time that he's been in treatment. He's continuing to be in treatment. He has not been able to work since he has been in treatment. He is a dentist, but that work nearly killed him, the stress and rigor of it in the context of what is also a very significant mental health episode.
Let me understand. So he's getting credit for jail for the inpatient treatment that he did?
That was the negotiated settlement
Okay.
agreement
I'm just
between.
trying to make sure I understand.
And yeah, I found that a little bit curious too. I don't know how exactly you want to note it on the judgment and sentence, but what he's getting 30 days of credit against his total sentences in all three cases concurrent for the purposes of the work that he has done on his mental health. I think if he hadn't done that work, there was a ITA holdover in Oregon. His mental acuity was so significantly impacted he was near death, and he is in a much better place today, but still recovering from what has been a very significant impact to his ability to meaningfully engage in things. I'd ask Your Honor to find him to be indigent just based off of the catastrophic mental and physical episode that he's had. He's still living in Southern Oregon at an inpatient facility, if I'm not mistaken. Are you still down at Grants Pass, Scott?
Yes.
The no contact order, I'll be clear with Your Honor, we haven't been able to get a hold of the victim. Scott, that number that your attorney gave you isn't a good valid number right now either. So basically what the agreement is between the city and Scott, he has some expectations about being able to engage in parenting time that are a little bit, I don't want to call them hypothetical, but there's something that's going to have to be worked towards as he gets himself with his feet underneath of him, transitioning out of an inpatient facility. If it becomes, right now there's a third-party contact provision that the parties have jointly proposed, even though the victim isn't a part of this discussion, because Scott indicates that he has these abilities to have contact with children that are a part of the family law case. But if at a later date that it makes more sense to have.
That's not, the children are not, those matters I think are being dismissed.
Correct.
So this court doesn't have jurisdiction to discuss contact with the children or things like
No,
that.
no, and he understands that. The no contact order allows for contact via third party to coordinate visitation, so long as there's a parenting plan order or
And
something
again,
along those
I've
lines.
signed, I'm assuming that's what was proposed by
Correct.
the city.
Yeah.
And it is agreed that the domestic violence treatment condition is stricken, it looks like, on the PTA.
It's actually free to argue, Judge. So I think the city is asking for that to be imposed. My client doesn't have a financial means of doing it. If he's ordered to do it, he'll do his best to try, but it's not covered by insurance. And I just think it's a recipe for failure. I don't believe that he'll be able to do it. If you look back at the PC statement, this was a situation that had some undertones of. Go ahead.
Hold on. So he's getting credit time. So I'm just trying to figure out, there's any of the, either other than the no contact order.
Mhm.
There's any conditions moving forward other than probation, certainly good behavior.
Stay out of trouble and don't have contact, absent to no contact.
So-
And then the
so-
DV provision, Your Honor, imposed.
So, Your Honor, the city is asking for the domestic violence treatment, evaluation and treatment. I understand that Mr. Yaman has some limited means due to his lengthy mental health hold. However, he is, I believe, employable. This is a 5-year probation period. I think at some point here, maybe 6 months down the road, he should be able to pay to start making a wage again, hopefully, and start doing the domestic violence treatment. I think it's appropriate in this case. So the city's asking for that. I did agree with Mr. Campbell that I would not oppose him making a pitch to the court and letting the court decide. However, the city would be requesting that.
Okay, but so my understanding, there was a protection order. I don't, so you also said that there was cases in Oregon.
Correct. There are no contact orders in Oregon, though. I want to be
I
clear about that.
understand. My question though, does he have a domestic violence treatment condition in Oregon?
Scott, do you have a domestic violence treatment in Oregon?
No.
And I guess the issue that I don't see, I mean, certainly a person can get a protection order violation. The court has clearly, a superior court reviewed it, found that there was a necessity for protection order. I don't see an underlying domestic violence charge though. Let me look at his.
There are
I could be wrong about that.
Well, and I can say very clearly that there are allegations of domestic violence that are uncharged incidents in the police reports. I'll be fair to Your Honor and the state and city in that regard. He was on an ITA hold when.
No, I know. He's been appearing in front of me for the last year from facilities the entire time. So I understand what's going on. I'm just trying to figure out. I don't know. I'm trying to figure out exactly what the intention is. So very clearly, all right, so I'll just proceed to sentencing. We're doing pleas on counts 1 through 3. My understanding is that counts 4, 5, and 6 are being dismissed pursuant to plea today.
Correct.
Count 1, 364 days in jail with 354 days suspended, leaving 10 days to serve. It'll be a $5,000 fine with all 5,000 suspended. I am finding that Mr. Yaman is indigent. Count 2, 364 days in jail with 354 days suspended. Again, 10 days to serve. $5,000 fine, all 5,000 suspended. Count 3, 364 days in jail with 354 days suspended, 10 days to serve. Again, 5,000 with all 5,000 suspended. Total of 30 days. Credit for 30 days. Probation for 60 months. Total financial obligation, because I am going to charge the domestic violence DV assessment, and I'm going to charge it 3 times. I think that's what the statute requires. So that'd be a total cost of $45. Conditions, no law violations, bench probation for 60 months. My assumption is that there is some manner of domestic violence, something or other. If it's not in Oregon, it's in a family law plan, or maybe it exists somewhere. If it doesn't exist somewhere, my perception would be it doesn't exist somewhere for a reason. I could be totally wrong on that, or I could be totally right on that. I don't know. I'm not going to impose it at this time. In particular, if he's been in a facility for the last year, I just think, again, this is not a circumstance where we're going to be able to attain that. That said, Mr. Yaman, if you continue to have issues with the courts, the court has jurisdiction over you for the next 5 years, sir, to certainly take appropriate action. I am not going to set a review date at this time. I don't think there's any active conditions for the court to be reviewing.
And just in fairness to Mr. Busby, because this is a transitional phase for him, I think that there was a provision for continued compliance with mental health treatment in the PTA. I'm not asking Your Honor to monitor that. I mean, it's been a year that he's been in these inpatient facilities. If Your Honor wants to, I just wanted to note that for the purposes of being upfront and candid.
Yeah, I'm not going to add that condition either.
Thank you, Your Honor.
All right, thank you.
Scott, you don't have future court dates out here. Stay out of trouble and continue to do what you need to be doing.
All right, good afternoon. We are on the record in the matter of Jefferson Capital Systems LLC, formerly Finger Hut Direct Marketing, versus Macman E. Moffatt. This is case 15-0794-GC. May I have appearances for the record?
Yes, Your Honor. Good afternoon. Dawn Marie Ozad, P63290, appearing on behalf of the plaintiff.
Thank you. And it is 1:11 p.m. This matter was noticed for 1 p.m. Mr. or Ms. Moffatt has not appeared, nor has anyone claiming to represent them. The reason I scheduled this hearing was because this is a request for a 10-year renewal. The most recent activity we have in the file is dated 2022, and it looks like nothing, not even 1 cent, has been collected on this file.
Correct.
And as of 2022, the interest alone was $627.06. So the question before the court is, why would the court renew this? To be more blunt, but
Well, Your Honor, because you never know when you might hit on something. We do, try garnishments. If we find any property, we'll do lien, but we just keep trying.
okay, well, it looks like garnishments have been tried in this case since 2015, sporadically. Also, just FYI, this case I don't believe this case was ever properly in the 54B district court venue, but we have it, at this point, but in the future, that might get more venue scrutiny, just FYI,
Okay,
in case you're filing other cases.
thank you. Yeah, I don't see that we've tried we did bank garns. It doesn't look like that we've tried a garn with the state of Michigan.
Well, I see Treasury, 22, 21, 20,
Oh,
19, 18, 17, 16.
well, I take that back. I don't know why I don't have copies.
Yeah, 16. Is that the state of Michigan? Here's an attempt on a bank, TCF National Bank out of Sioux Falls,
Right.
16. And I guess I'm also wondering, have you done anything to verify the address?
Yes, we do periodically, we do research to verify their address.
Okay. Again, I see nothing in, well, this is what we call a hybrid file because in 23, the court went to the My File system.
We do bankruptcy scrubs, we do military scrubs, we do deceased scrubs.
Okay. Okay, well, I believe under the law, I have to grant this. I'm going to follow the law, obviously, but well, anyway. Let me just check something here if I may.
Well, it looks like we did hit on a bank, but the funds were Social Security.
And oh, happy day, I'm locked out of My File. So, well, why don't you, I will go ahead and sign this as soon as I can reach it. Which could be a while at this point, but not on my part. So, all right, well, I guess I'll go ahead and sign. Thank you.
Okay.
Anything further for this record?
No, Your Honor. Thank you so much.
Thank you. Happy Thanksgiving.
Thank you. Bye-bye.
All right, good afternoon. We are on the record in the matter of University Apartments versus Anthony Zhong and Aidan Calhani. This is case 25-1024 LT. May I have appearances for the record? You're muted.
Here.
Okay, Mr. Calhani, can you turn on a camera or something?
Yeah.
Okay, good. First, we'll start with Mr. Keski because he represents the plaintiff. And Mr. Keski, you're muted.
Good afternoon, Your Honor. Don Keski for the plaintiff. Also on Zoom is Debbie Wren from DTN, agent for the owner.
Right, thank you. And now representing Mr. Zhong, Mr. O'Keefe.
Good afternoon, Your Honor. Brian O'Keefe on behalf of the defendant, Anthony Zhong.
Thank you. And now, Mr. Calhani, could you state your name for the record?
Aidan Calhani.
Great, thank you. So this is a first hearing in a landlord-tenant matter for non-payment of rent. Would the parties like to speak in a breakout room about settlement or options?
That'd be fine, Your Honor.
Okay, Mr. O'Keefe.
That's fine with me, Your Honor.
Thank you. Mr. Calhani?
That's fine.
Okay, so we're going to put you in a breakout room. You'll come back and then we'll proceed. Thank you.
And
Thank
we'd like Miss Wren to be included.
Always.
Yeah, okay.
Hello, Judge.
All right. Good afternoon. We are back on the record and the parties have been in a breakout room. For Mr. O'Keefe, I don't need to tell you this, but for Mr. Calhani, I need to tell you, because this is a legal proceeding, you have a right to be represented by an attorney. That's the good news. The not so good news is that here in civil court, we don't provide an attorney for you. However, I may have some telephone numbers that would help you out if you'd like them.
Sure.
Okay. Are you currently enrolled at MSU?
Yes.
So you already have an attorney. It's Student Legal Services. The telephone number is 353-3716, Student Legal Services.
You said 353-3716.
Yes.
Okay.
Second, I have a website for you, michiganlegalhelp.org, all spelled out. This is designed for people who are representing themselves in court. And if you log on between 11 a.m. and 2 p.m. daily, there's a live chat, and they may be able to answer your questions directly. Now, would you like the telephone numbers of some organizations that might have funding to help you get caught up on your rent?
No, thank you.
Okay, I will give you one because it's my favorite thing right now. It's 211. It's like 911, but for social services. So whenever you need help or you see someone who needs help, but it's not quite a police issue, 211 will help you out. Okay. So the party's been in a breakout room. Mr. Keski represents the plaintiff. He has burden of proof. He gets to go first. Then I'll go to Mr. O'Keefe, who is the first defendant, representing the first defendant to appear. And then I'll go to you, Mr. Calhani. So Mr. Keski, and you're muted again. What do you have to report?
Yeah, during the breakout room, actually, Your Honor, there's actually two cases going on. One is the landlord-tenant case for non-payment of rent.
Okay.
And then there is a separate small claims case that's been filed. And that's on behalf of Mr. Zhong. And related to the same property and the same lease and the same tenancy. So what we would suggest is that we will file a demand to transfer the small claims case to the district court. So it'll probably have a different case number in district court because obviously now we have counsel on both sides representing Mr. In the Zhong issue. And the other case would go forward because there's still the other tenant who signed the lease. But we'd like to suggest a date in January, probably the last 2 weeks of January, as a common date for both dockets. Because in the meantime, we'll try to resolve both dockets and sort of on a global basis, hopefully.
Okay, thank you. Mr. O'Keefe, is that an accurate statement?
Yes, we concur, Your Honor. We're going to remove the small claims matter to district court. The small claims matter is before you, Your Honor, so it'll be removed to district court. It'll get a separate number as Mr. Keski cites, and then we would like to work toward a global settlement of the issues. And with the holidays, we feel like the end of the last 2 weeks of January would be a good date to hold us to try to get a settlement in place.
Okay. And then, Mr. Calhani, is Mr. Keski's statement accurate?
Can you repeat the statement?
Repeat Mr. Keski's statement?
Yes.
Mr. Keski?
Yes, as far as your case, Mr. Calhani, your case still is going forward for a second date as to the rent issues, and obviously would be open to be discussing any resolution of that case with you between now and the next court date.
Which should be sometime in mid to late January.
Okay, and Mr. Keski, do you agree to a late January date for, well, I mean, that's one case against the two parties, but for a landlord-tenant case, that's quite a long timeline.
That's fine, Your Honor.
Okay, so,
Because it makes more sense to try to resolve both cases on a side-by-side track rather than have it, dealt with separately.
Understood. Sometimes, and Mr. O'Keefe, I don't think we've met. Sometimes when people come in from general civil litigation, which is what my much better half does, their timeline is very, very different than your district court landlord-tenant, residential landlord-tenant matter. So,
I understand, Your Honor. Thank you.
okay.
But we would urge Mr. Calhani to try to, keep working with DTN to pay rent is what he can and to try to resolve his case. It's always open for settlement between now and the next date.
Okay. So,
Yeah.
Mr. Calhani, first, is that an accurate statement? Do you want a date in late January? Do you want a future court date to continue to resolve this matter?
I mean, if I have no choice, I continue. I'm gonna continue to keep paying my rent. So
Okay, that's good. Anything that you'd like to add to Mr. Keski's statement, Mr. Calhani?
no.
Any questions?
Yeah. So if Anthony continues to not pay his rent, how exactly will that affect me? Like in the long run?
Okay. Well, I'll let Mr. Keski answer that, actually.
Well, Mr. Calhani, you signed what's called a joint and several lease, which means any one of the two of you can be responsible for the entire lease amount if one of the parties backs out or doesn't perform. Although you can always file a small claims case against Mr. Zhong for the difference. However, again, we don't want to foreclose settlement discussions with you. We're trying to work out an arrangement. And also, I think you should consider asking for rental assistance. There's a couple of agencies which I think were included in your papers, including the Michigan Department of Health and Human Services, that is set up to help tenants pay rent when there's circumstances that arise. So you shouldn't foreclose that possibility of getting at least part of that rent paid for with rental assistance in addition to your own efforts to pay rent.
And I'll answer that, another part of that question. So, Mr. Calhani, you and your stuff aren't going anywhere until at least 10 days after the next court date. Maybe that'll help. The locks are not going to be changed on the door. Your life will proceed until we come back in late January. Then at that time, because you and Mr. Zhong are on a joint and several lease, one or both of you owes the full amount. So if he hasn't paid a dime since you moved in and still isn't paying a dime, for you to continue to live there, somebody has to pay the full amount of rent, and vice versa. Does that help?
Yes, and the deadline is the end of January, like you said.
Well, it sounds like, based on what you said earlier, you've consistently been paying rent. And so I can't give you legal advice. I can give you life advice, which is odd because I'm a lawyer and I'm not so sure about my life, but I can give you life advice, which is number one, stay in conversation with Ms. Wren all the time. Okay. And I would say keep paying at least your portion of the rent. And number three, I would follow Mr. Keski's advice, which would be to seek rental assistance. Okay. And again, I go to 211. They usually have a pretty good line on who has funding. I go to the State Department of, now it's Health and Human Services, or it used to be called DSS, Department of Social Services. They have what's called SER, which is State Emergency Relief. And SER has helped people in the past when they've had roommates who haven't been able or willing to pay rent.
Mm.
Most often I see that as, say, a relationship that has fallen apart and the other person moved out, and then someone owes all of the rent they thought they might share with someone. So pursue that, okay? Then we will come back in late January and we'll get a date in just a moment. Instantly pops up. So January 26th of 26. So 11:20 a.m. January 26th. But Mr. Calhani, one of the best things you can do is stay in communications with Ms. Wren. Okay?
Yes.
And call Student Legal Services. And also you want to mention to them that you've got a landlord-tenant matter where your co-defendant and co-tenant is also well, let's try to find a way to put this in a brief but significant voicemail. So your roommate has a lawyer and is suing the landlord. And again, this is just a representation based simply on what Mr. Calhani has already said, that you are paying rent, but you are afraid that you were going to be evicted.
Correct.
Okay. So that's the message you want to get them, and that you're headed for a second hearing in this matter. Okay.
I will help him, Your Honor. I'll give him Mr. Meyer's telephone number direct, and he can say my name, and Mr. Meyer will call me directly.
So David Myers, one of the attorneys at Student Legal Services, is in regular communication with this court and Ms. Wren.
Ms. Wren, can you give me the amount of damages that you're claiming presently? It was $4,000.
$4,660.91.
Very good. Thank you.
You're welcome.
All right. Anything further in this matter at this time? Mr. Keski?
I don't think so. Thanks a lot.
Okay, thank you. Mr. O'Keefe?
No, thank you, Judge. We appreciate it.
You're welcome. Mr. Calhani?
No, thank you, Judge.
Okay, well, happy Thanksgiving to all of you. Mr. Calhani, I hope you take this in the spirit with which it's intended. At some point, I hope you never see me again in your life. Now, feel bad for Keski because he's got to be in front of me like twice a week, several times. And Mr. O'Keefe, I don't know that we've met. Welcome to 54B.
My pleasure, Judge.
And Ms. Wren, happy Thanksgiving as always.
Happy Thanksgiving to you as well, Your Honor.
Yeah.
Thank you. That is all for this record.
Okay. Thank you. Bye now.
Thank you.
Thank you.
On the record in the state of Michigan versus Faison Flanagan, 2502911FY.
Ross Marchino from the people.
Good afternoon, Your Honor. Dwayne Silverthorne from the Office of Public Defender on behalf of Faison Flanagan, who is standing to my left.
And you are Faison Flanagan?
Yes, ma'am.
Today's the day meant to be sentencing. Mr. Flanagan had a favorable plea agreement where he pled to a misdemeanor. The other charges were dismissed. He had a no upfront jail agreement, 7694A. All of that can be forfeited by lack of cooperation between plea and sentence. And here we are with a lack of cooperation report from probation. I'll let Mr. Silverthorne talk first about why Mr. Flanagan didn't do what he was supposed to do with probation.
When I left the last time after the plea that I left Mr. Flanagan, it was at the downstairs at the probation department, in which he filled things out. And in speaking with him last week, he thought that was it. He doesn't receive snail mail very well, right? But last week, a week ago today, when your court was advised of the document that you received, I would probably within 5 minutes of receiving it, saw it and called Mr. Flanagan. I was able to get a hold of him by phone immediately, explained what was going on, told him he needed to immediately call his probation agent, Nathaniel Nevis. I confirmed this morning with Mr. Neves that Mr. Flanagan did exactly that, but to no surprise, Mr. Neves says we can't work that fast. I can't possibly have a interview, set up an interview, and have a report to the court that quickly. So you'll just have to come into court. I sent an email this morning to Mr. Flanagan about this. The court, could revoke his bond for that, but that he needed to appear. And I note that he's appearing today. I think it was that either email gets to him okay and phone calls get to him okay. And I think things sent by mail perhaps did not get to him and he did not get to him okay. And he simply, it was a miscommunication. He is here today.
Reset the sentencing date, but because no report was done, no interview was completed, that's part of the problem. It takes weeks to get these things done. I'm going to add a bond condition that you're ordered to enroll in veterans intervention programming within 10 days. If we return for sentencing and you have failed to comply with my order to enroll in counseling or failed to comply with your interview, I will see that you're not fit for probation. Because part of probation is following directions. And so I need you to demonstrate that you can do that.
Okay.
And that you want to do that. If you're ever confused about what you should be doing or where you should be contacting your attorney or probation right away. Don't wait till they contact you to tell you it's too late. That's not helpful. Get a new date for you and then get you down to probation to go set up your new interview date. New sentencing date is January 15 at 1:30. Okay, so we'll be back here January 15 at 1:30 for sentence. In the meantime, you're going to go to probation, get your interview date. They should give you information about starting the counseling program. And then you're going to attend your interview. And then we'll all be back here together to find out how it's been going. Okay? All right.
Thank you.
Thank you. On the record, in State of Michigan versus Cameron Rodriguez, 2503473FY.
Good afternoon, Your Honor. Abigail Wilson on behalf of the people.
And Luke Goodrich from the Public Defender's Office here to represent Mr. Rodriguez, who's appearing over Polycom from the Ingham County Jail today.
And you said you are, in fact, Cameron Rodriguez in the video?
Yes.
Okay. Today's the date probable cause conference. We have a preliminary exam scheduled for next week. Have we decided what we're going to do about that hearing?
Yes, Your Honor. Your Honor, at this time, we'd like to leave the matter set for preliminary exam at this time and then address bond when appropriate.
All right. Ms. Wilson, you be ready?
Yes, Your Honor.
Okay. Mr. Goodrich on bond?
Thank you, Your Honor. Your Honor, his bond is currently set at, hang on, oops, sorry, I have 30,000, 10%. He is about 2 weeks past 18 years old. I understand the nature of the charges in this case, but he is a senior in high school at Sexton High School, still trying to take classes there to get his degree. I would ask the court to consider reducing this to a PR bond with tether, so the court has some monitoring over him. Like I said, I understand, the charges are, fairly significant in this matter, but he is a very young man. He has a place to stay with his mother on Hosmer Street. So we would ask the court to consider a PR bond prior to the preliminary exam.
Ms. Wilson, I guess I'm curious because I'm looking at the affidavit of probable cause and it mentions that there's a charge out of Langston Township. Is that case still open?
I did not, it might have been one of the juvenile cases that he had. And we had, there was a domestic violence and a resisting and obstructing with the domestic violence with the same victim. I believe it was actually an aggravated domestic violence. He was a juvenile at the time, so it wasn't juvenile court. However, after this offense, we are considering doing a traditional waiver for those offenses into adult court. As far as bond goes, this was a pretty violent assault. The complainant in this matter did indicate to me that she miscarried because of this assault. She lost quite a bit of blood. She was in the hospital. It was pretty violent and pretty life-changing. She also or I should say, I was perusing through his jail messages, and I did see that he was attempting to relay information to the complainant in violation of the no contact order through his mother, and as of yesterday tried to relay to tell the complainant not to come to court through his mother. I do have some pretty serious concerns about Mr. Rodriguez being in the community at this point. I think the bond is more than appropriate.
Based on the serious nature of the charges, because there are several, one of which includes aggravated stalking, which is quite a serious offense. Also, the affidavit of probable cause that says there has been police reports made September 6, October 21, October 30, and then an alleged bond violation also on October 30, and that doesn't include the October 4, where apparently the other side was arrested. I believe that it's not appropriate to change bond. I also will take into consideration the allegation that there may be ongoing efforts to violate a court order, which we do not take lightly either. Mr. Rodriguez, if you violate the court order of no contact, whether you're in jail or out of jail, you could be in contempt of court, which is punishable by up to 93 days in jail and or $7,500 in fines consecutive to that which you already face. You should also understand that the prosecutor can listen to your calls. They can use your calls against you. They can use your calls to add additional criminal charges. If you post bond, you could be arrested without a warrant and the bond could be revoked, and then you'd be facing all those other consequences as well. So, you know, bond violations can take a bad situation and make it way worse. So I'm going to deny the motion to change bond at this time and tell you, Mr. Rodriguez, don't make a bad situation worse. Anything else we should address for Mr. Rodriguez today?
Not from the people.
No, Your Honor. Thank you.
Mr. Rodriguez, you're going to see Judge Greenwald next week on December 4 at 9 o'clock. She'll be sitting in Judge Simmons' courtroom. We're all set for today. Thank you.
All right, this is case 240649. This is People of the State of Michigan versus Cody Green. Answers for the record.
Ricky Inger on behalf of the Probation Department.
Good morning, Your Honor. May it please the court, Lawrence Nolan, P. number 25908, on behalf of the defendant, Cody Green.
So this is the day and time set for a probation violation. Will this be a plea or request for hearing?
It'll be a plea, Your Honor.
Mr. Green, sir, do you understand what's going on?
Yes, sir.
You understand it. As a person charged with a probation violation, you have a right to have a hearing. At that hearing, it'd be the responsibility of your probation officer to prove that you are in fact in violation. If she couldn't do that, then the violation could potentially go away. You can also plead guilty to the violation by accept a guilty plea. It's basically the same as if you had been found guilty. You could end up having the terms and conditions of your probation change. You can also end up having to serve some jail time. Jail time is tied to the underlying offense. And the underlying offense is, looks like it's a drunk driving offense. Is that right?
Yes, sir.
Yes, sir.
So you could face up to 93 days in jail, but you get credit for the jail time that you've already served. So you understand all that?
Yes, sir.
Understanding that, you still want to go forward with your plea?
Yes.
Raise your right hand. Do you swear or affirm that the information that you're going to provide to the court will be the whole truth?
Yes.
Lower your hand. Want to make sure that you're doing this voluntarily. Has anyone threatened you or forced you to get?
No.
Anyone made any promises to you to get you to do that?
No, no coercion.
So you're pleading guilty because you are in fact guilty?
Yes.
And this is your own personal choice to plead guilty?
Yes.
So you were placed on probation and prohibited from using controlled substances, true?
Yes.
And that you used a controlled substance known as methamphetamine?
Yes, I didn't originally know.
But that's what you tested positive.
But that's what I tested positive for. And
try not to talk when I'm talking, okay? And you tested positive for using that on a urine drug screening on October 17th. Is that right?
Yes.
And it looks like you failed to submit to testing after that on October 31st. Is that true?
Yes.
That you also failed to attend counseling as directed on November 5th and November 9th. Is that true?
Yes. After the
And that you also failed to attend testing on November 10th. Is that true?
yes. Once I had received the violation and the warrant, I understood that I would be going to jail and that I could be revoked. So I was trying to make some money so I didn't lose everything I owned while I was in jail.
All right. I find that the defendant has knowingly, intelligently, and voluntarily tendered sufficient factual basis for the court to find him guilty of all the violations as indicated on the record. Before the court, Mr. Nolan, sir, would you like to be heard?
Yes, Your Honor. May it please the court, Your Honor. This has been a struggle for Cody. I've known Cody for a long, long time. It's very difficult for him sometimes to follow directives. And I think once he realized that he had missed hearing, he just threw in the towel because he knew he was going to be violated. His mother is here in the courtroom today. Sierra, his significant other, is in the courtroom today. They've been both very supportive of him. He had recently bought a home on parts within the last year or so from his grandfather. He's concerned about making the payments on the home. When he came before the court, he did the number of things which I gave him a list of, but I was impressed. Clients don't always do it. He did the impact weekend, which I thought was very good on way back June 24th of 2024. I said that's great progress. He did June 26, 2024, the highway safety seminar, defensive driving. He did numerous hours of over 25 hours of community service, AA verification. And I think as things went on, I think the court was very lenient, but very strict about maintaining his connection with probation department and testing and wearing a tether. He wore a tether and had this violation occur. And I think he just, out of frustration, threw in the towel and said, I'm going to go to jail. I'm just not going to show up at court. He had a pending probation over in Eaton County. He failed to go to that at the same time because he just said, I'm going to jail. I have very little sound reasoning as far as the facts of the law to say that Miss Anger's recommendation is unreasonable. I think probably it's better that he serve a jail term than continue probation. I just think it's more difficult for him mentally and logistically. He still does not have a driver's license, which he needs to have at least a year of complete sobriety. I think he's been sober, but for this last episode of testing with the methamphetamines, I think he thought that he was working, I know, long hours at night and thought that this would give him energy. And a friend said this is an energy pill or something. He doesn't deny taking it. He doesn't deny testing positive. He's here before the court. The only thing I would request is that we be allowed to, I'm going to go to Eaton County today and see if he can enter a plea on that probation so we have a concurrent sentence, but that he just be released. I think he served about 23 days as of.
What does your math show?
17 days, Your Honor,
17 days.
Oh, I thought
including the time he has served.
it was 17 on Friday, the 21st. So I'm adding a couple more days to this.
This is including, it's up until today.
I'm
I
sorry.
usually do it that way.
Oh, well, that's efficiency. I just didn't realize that was the formula, but, I'd like to see him serve his time and with the courts, I would ask that he be released just before Christmas holiday. It will, with time served and credit, and discharge him from probation. I think he has capability, especially, with his, significant other, Sierra. She's not gonna tolerate any drugs. She's not gonna tolerate any excuses. And she'll be gone, and he'll lose, a very, important person in his life that's, been there for him and cares about him. And his mom has been through this with him. We just want the best for Cody. He's a talented drywall. And how can you be a talented drywall? Because you like what you're doing and you're good. And
I'd like to point out too that I haven't had a drink since August 31st, 2024. So as far as the use of this program did put a staple in my alcohol use in going forward. I haven't had a drink in over a year.
so, Your Honor, I appreciate everything this court has tried to do. And it's the old adage, you can bring a horse to water.
You lead a horse to water, but you can't make him drink.
And we've done that. I've respected what this court has done and given Cody that chance. Admittedly, he's failed and he understands it's all on him. And when we make decisions, yeah, I remember when our kids were growing up, we said they wanted to make their own decisions. They wanted their freedom. They wanted to do this or this. And I told them that you can make your own decisions, but then you have to live with the decision you make and either enjoy the benefits of that decision or suffer the consequences if it's a bad decision. And Cody's, I hate to say maturing at age 27 or 28, but all experiences in life, I think, make a person better, whether they're good experiences or bad. And there's a French philosopher that once said, adversity tempers the human heart, in which it finds its true meaning. And I've always felt that you got to go through some tough times. These are tough times, but you got to get your act together. And you'll find its true meaning and what is important to you in life. With that said, Your Honor, I think I'm not a mathematician, but if there's 17 days and another 30, well, we'll probably be past the Christmas holidays. So I'd ask that possibly he be released. And I'm not sure what Eatontown is going to do, but I certainly will indicate what Your Honor has done. Release him before the holidays and discharge him from probation.
Opportunity to speak.
I've learned a lot through this trial and error.
What have you learned?
One, what my previous drinking had done to myself and to the others around me. The vulnerabilities that put me and others in, especially drinking and driving. I've learned that I have to take responsibility for my actions. Being that it was my birthday or whatever excuse I may have told myself at the beginning, that there is, never an excuse to get behind the wheel and drive after any alcohol.
What about your use of meth while you were on probation?
That's more of a confusion in that I was taking. I thought I was trying to find energy, finish many jobs I had going on. I was working late into the night, and
that doesn't make any sense, right?
Misled.
That you were taking something from somebody that was not prescribed to you is the height of arrogance. You don't know what it could have done to you. Right now, it's just having you locked up in jail, but it was killed you.
I was desperate.
Not desperate enough to play with your life. You're taking something into your body that was a very powerful narcotic. You didn't even know it. It's crazy. You have to think about who it is that you're trusting with your life. And obviously, they did not earn the right to be able to put you in a position like that. Go ahead. I don't want to cut you off.
I guess not necessarily because of probation, but through this, I am running a household. I live with my girlfriend and my 2 dogs. I cut wood. I work hard to save every dollar I can in every corner I can, and I found my purpose at home, opposed from running around. Just trying to work hard so I can get home.
Do you understand, Cody, what Judge Allen just said to you?
Yes.
Do you understand that putting something into your mouth or body that a so-called friend says this will give you energy could be something that would kill you?
I knew he would.
Do you understand the judge doesn't want you to die? Do you understand that your mother doesn't want you to die? Do you? Do you understand that Sierra doesn't want you to die? Do you understand there's a lot of people that love you and don't want you putting crap in your mouth that could kill you? Like fentanyl. How did you know that wasn't fentanyl? How do you know do you know you're lucky to be alive here? Because fentanyl could have killed you within 10 minutes. That's who cares about you. This court, your family, your girlfriend, and yeah, me. This isn't a pharmacist that wrote a prescription that you gave him $20 for the prescription. This is some friend, you call him friend, that gave you drugs to put in your friggin' body and kill you.
Actually gave you poison. You're taking something into your body that you don't know what it is and what it's for. Crazy. You're lucky to be alive. Get yourself a tissue. You're a grown man. You're supposed to be responsible for what it is that you do in your life. And you're doing things that are just totally irresponsible. For no other reason than you think it's a good idea. Not that you know that it's a good idea, but you thought it was a good idea because you're so tired and you got all these responsibilities. And it could have killed you. But you didn't know what it was. But you can bank on this. It was basically poison. Now that you know what it was that you did, you can count that as poison because you did something, you took something into your body that could have harmed you. I'm not going to sit here and belabor the point. I am going to revoke your probation. I'm going to order that you serve 93 days jail with 17 days credit, and I'm going to order that you serve the balance of the jail time. But I'm actually going to suspend the jail time after you serve an additional 30 days. You go and you find out what's going on with Eaton County. Maybe you'll get lucky. Maybe they'll do the same thing that I've done. Maybe you'll actually get released in time for Christmas. I don't know. It's not really important because you don't necessarily have to be here right now. You could be dead because you did something that was totally irresponsible towards your life. And you don't necessarily get a chance for a second chance. But somehow or another, you did get a chance for a second chance. So what you decide to do with it is going to be up to you and your family. But that's going to be the ruling of the court.
You say the ruling again? I don't think I fully understood it.
I said that your probation's revoked. You're ordered to serve 93 days jail with 17 days credit. But what I'm going to do is order that you serve 30 of those additional days and suspend the balance of those jail days. So you don't have to serve the entirety of it, but you still need to go to Eaton County and figure out what they're. You may decide to just throw the book at you. And if they do, I don't blame them. Yeah. So you're to set up a payment plan with this court to pay off your fines and costs by January 15th. Don't make me come look for you.
Now, when I got my alcohol tether at Eaton County, they got me fired from my job. So if I could have another month to find a job.
To set up a payment plan.
Oh, to set it up. Okay.
Be very careful about the words that I use.
Yes.
Is there anything else? I think you owe your attorney an apology. I don't think I've ever seen Mr. Nolan get worked up so much as I did today.
I owe a lot more than apology.
I apologize to the court, Your Honor, but the frustration has reached a level.
You've been doing this a long time, Mr. Nolan. I can imagine that there's a whole lot that's been building up over the years. So no need to apologize.
Thank you.
Okay, that's going to be off of the record.
Thank you.
Okay.
Thank you, Your Honor.
You're welcome, Ms. Anger. All right, next matter is case 25.
Sorry, I've not let them in yet.
I thought that they were in the courtroom.
The bench trial folks are here.
We have all the 230s in waiting room.
So the folks that are in the courtroom are
Miss Kember and Mr. Rettman.
Rettman, right? Nicholas Rettman.
Yes, sir.
Yeah, that's what I was looking for.
Would you want me to let all the others in or not yet? We might have some witnesses to this case on Zoom.
You guys have witnesses that we're expecting? No?
According to Ms. Wilson, there were.
Okay.
So,
All right, this is case 25-2773. This is Aliza Kember versus Nicholas Rettman. You guys would come up and join me? So it's my understanding, well, let me make sure that I have the right people here. Are you Miss Kember?
yes.
And you are Mr. Rettman?
Yes, sir.
All right, it's my understanding that this whole discussion is about a dog that happens to be in the custody of Mr. Rettman, and that Miss Kember would like to have the dog returned to her. The dog is named Duke. Is that right?
Correct, Your Honor.
And that there has been some conversations between you and Mr. Rettman about having the dog returned to you, and see that there were some emails or something that was sent over to me discussing these things, and don't know if there's really disagreement with regard to the custody of the dog, but it looks like this is your dog, but somehow that you two were in a dating relationship and you broke up and he has your dog.
It was,
I saw what you were saying that you didn't really have an interest in the dog and that you would return it to her, but then there are going to be some vibes going back and forth about the breakup of the relationship. Yeah. So it sounds like this is a rather simple situation. I hesitate to say that because that's why courts exist. It's because sometimes people can't really communicate effectively with each other. And so I saw some emails back and forth between the two of you, and I'm not going to get into the details of what the email says. I mean, it's really basic what we're dealing with. That it's your dog, you want you to have your dog back. He has the dog, doesn't really have an interest in keeping the dog. And I think that.
I don't think that's true. I apologize for interrupting.
So if you'd like to speak to me, you actually have to stand up.
Apologize.
Sure. What is it you think that I need to know?
Well, I've been financially responsible for him, and I've also been emotionally attached to him. We fish often together, and we run often together. I will admit that she spent more time with the dog due to the fact that I was working.
What's her dog? Right?
No, he is registered to me.
It's her dog.
It was our dog.
Who purchased the dog?
I did.
You purchased the dog for her.
I purchased the dog for us. He was an addition to our family.
Are you chewing gum?
Yes, I apologize.
Do that. There's tissue right next to you. Go ahead. See what else you have to say. Because this strikes me as being a rather simple question.
He has been. We shared him throughout our relationship. I purchased the dog. He was not an anniversary gift. He was an addition to our family. I have paid for his vet bills and paid for his food, and
so all of that went sideways when you guys broke up.
Yes, sir. When it was maybe a two-step breakup, I would say. We were doing a long distance relationship where she was living at her father's house, and we were sharing him week on and week off. What changed that was the fact of she had threatened to keep him and not let me see him, which we ended up working out earlier in the relationship before the relationship was over. And then
it's a good thing you didn't have kids, huh?
Yes.
Yeah.
Yes. But yes, we shared the dog for the time being, and then once the relationship was over, he was in my possession.
That's just happenstance, right? There was no agreement.
Yes, sir. I was accused of manipulating her into taking the dog.
Actually, I've read the email, so you may not want to go there. Okay.
That was just what was in her statement.
Okay. Is there anything else that you think I need to know?
He is around somebody 24/7. Karen, my sort of stepmother, she works from home. He brings her very much security. It's not the greatest neighborhood, so she feels a lot more comfortable with him in the house.
Sure she does. Okay. Anything else?
No, Gary. Just the fact that he was registered to me, and
well, I understand that.
Also, she attempted to force her way into our house.
Did you call the police?
Yes, Your Honor.
They arrest her?
No, Your Honor, they did not.
They charge her with harassing you or anything?
We have been speaking to detectives.
So they haven't.
No. But it is my understanding that when I was at work, she showed up at Miss Mataska, who is the person that I live with, her house unannounced, and was trying to get in the house to get Duke.
It's her dog.
Yes, we also have a cat.
Cat's not part of this. The only thing I'm thinking about is the dog named Duke.
Yes.
Okay.
Dog.
So as far as I'm concerned about the cat's yours to keep.
Okay.
Okay.
Yes, sir.
Do I need to add anything to this? I think that I understand pretty well.
I did prepare an opening statement if you'd like to hear it.
Don't need it.
Thank you.
I think that what I know about the case is sufficient for me to rule in your favor for the dog to be returned to you forthwith. That means immediately.
Thank you, Your Honor.
Okay. Any problem with doing that, sir?
Yes, Your Honor.
What is the problem?
It was a dog that we shared. But I am also very much attached to.
I haven't made my intentions clear to you that I want her to have the dog. You bought the dog for her.
For us, Your Honor.
You bought the dog so that she could have the dog. And then when you broke up with her, you decided that you did not want to just summarily turn the dog over to her. So now there's a court case for a judge to determine what should happen.
And she broke up with me here.
I understand.
Oh.
And maybe if you had broken up with her, we wouldn't be here. But the fact of the matter is we are here, right?
Yes, sir.
And it is the job of the judge to do what? To make a decision.
Yes, sir.
I've listened to both of you, and I've come to the conclusion that she should have the dog returned to her. Okay? And I want that to happen immediately. I don't want there to be any games played. I don't want you to try and do anything foolish with respect to what it is that I'm ruling, because that would actually probably make me very angry.
Yes, sir.
We don't need that. Okay? I'm going to give you 24 hours to return the dog to her. And I don't necessarily want the two of you to have personal contact outside of this courtroom. Is there someone that I can trust? And this, the two of you agree to a third person that the dog can be turned over to, that can make sure that she gets the ownership of the dog immediately.
I live 2 hours away. My father is here with me right now.
Okay.
So if you would like to contact with my father about the return of the dog.
Where's your father at?
He's outside.
Why don't you ask him to step in, please? Sir, if I can get you to come up to the podium.
Yes, sir.
What is your name?
My name is Irvin Kember.
Mr. Kipper? Oh, Kember.
Kember.
I'm sorry. I thought you said Kip. Mr. Kember, I've just actually held a hearing with regard to Duke, which is a dog that was purchased by the defendant, essentially as sort of a gift for your daughter. And I've just ruled that the dog should be returned to your daughter.
Yes, sir.
And I want you to be the person. I don't want the two of them to have any contact outside of this courtroom. So I'm asking you to make sure that you go with the defendant Mr. Redmond to get the dog and to bring the dog back to your daughter.
Right.
Can you handle that?
Yes, sir.
I don't know what your relationship is with Mr. Redmond. Do you enjoy a relationship with him at all?
No hard feelings. I think we should be able to handle that just fine.
Well, I want it to
Sorry, I
happen.
heard that microphone is off.
Oh, it is off, isn't it? So I want to have the dog no later than 24 hours returned to your daughter, and you can make sure that that happens, right?
Yes.
So I don't know if you're going to do that today or tomorrow, but within by 3 o'clock tomorrow. Actually, that's Thanksgiving, isn't it?
It is.
Are you planning to be around tomorrow?
I'm actually leaving to Tennessee in the morning.
We can get it done today.
Yes, sir. We can.
Okay.
Is that okay?
Why don't you guys get together after you leave the courthouse and make that happen, okay?
Yes, sir.
Is there any reason for me to keep this file open after this point in time, sir? No? All right, then this is going to close this matter out then. Thank you so much for your time, Mr. Kember. I appreciate you being here because you're a disinterested person that can make this happen, and I think that you'll be a responsible person to ensure that it happens as quickly as possible. I'm putting a 24-hour time limit on this. Actually, I should probably put an 8-hour time limit on it because you're going to be having plans tomorrow to do what you need to do. I wanted to give Mr. Rettman an opportunity to say any goodbyes to the dog that he felt like he needed to say. So we'll go with him and see if you guys can get this worked out, okay?
Yes, sir.
Any questions or concerns for you, Miss?
No, Your Honor, thank you.
Mr. Rettman?
No, Your
All right, then that's going to be all for these proceedings. Thank you.
And we are on the record in the matter of the City of Wyandotte versus Nicole Weems, 251269.
Good morning, Your Honor.
Good morning.
Your Honor, John Goldblatt, P 30758, on behalf of Ms. Weems. Ms. Weems, please put your name on the record.
Weems. Okay. Ms. Weems, you're on probation with this court.
Yes.
And yet, here you are. Counsel, as to the arraignment.
Your Honor, as to the arraignment, she stand mute to the charge, waiver form reading of those charges, asked that a plea of not guilty be entered on her behalf.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and as to the pretrial.
As to the pretrial, Your Honor, I've had an opportunity to discuss this matter with Ms. Weems. I've also discussed with her the fact that she is on probation and that this would have an adverse effect, entering into some sort of plea with respect to that. But knowing all of that, she wishes to avail herself of the plea that's been reached. My understanding is in return for a plea of guilty to operating while impaired, the people would move to dismiss the no charge of operating while intoxicated by BAC. Explain to her constitutional rights and explain to her the rights that she would be waiving by entering into this plea agreement. She wishes to avail herself of this opportunity, and she does understand those constitutional rights. Is that correct, Ms. Weems?
Yes.
And there are no immigration issues.
Please raise your right hand, ma'am. You solemnly swear from testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes.
And you've gone over your advice of rights with your attorney, correct?
Yes.
As to the amended charge of operating while visibly impaired, how do you plead?
Guilty.
You've gone, and you understand the rights that you've gone over with your attorney, correct?
Yes.
And you understand the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yes.
You do understand, ma'am, that this is likely going to trigger a probation violation, correct?
Yes.
And knowing all of that, do you want to continue with your plea?
Yes.
I can't hear you.
Yes, ma'am. Sorry.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues? I'm sorry?
No.
Counsel, if you can please pardon your client.
Ms. Weems, on August 25th of 2025, you were operating a motor vehicle in the city of Wyandotte.
Yes.
And at there come a point in time where you came into contact with some Wyandotte police officers.
Yes.
And prior to coming into contact with those wind-up police officers, were you consuming alcohol?
Yes.
And,
Ma'am, you need to keep your volume up, okay, please?
and what were you drinking?
I had a bit of bourbon.
You had a bit of bourbon.
Yes.
Would you state you had quite a bit of bourbon?
Yeah.
Okay. And, when you were, seen by the police officers, they gave you some certain field sobriety tests, is that correct?
Yes.
And, eventually you were detained and you took a PBT as well as a breathalyzer test, is that correct?
Yes.
And the results of that breathalyzer test were 0.1
.184.
and 184, is that correct?
Yes.
Looking for the other one too. Thank you, Your Honor. Defense is satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. And the court will accept your plea, your very generous plea that you were provided, ma'am, and dismiss the original charge per the plea agreement as to bond counsel.
As to bond, Your Honor, Ms. Weems has complied. She's appeared here today. She's gainfully employed. As the court is well aware, she is on probation to this court. This was obviously when we spoke to her. When I spoke to her, I informed her that this would be a violation of that probation. She understood that. She told me, when I questioned, she said, what was going through your mind? She said, it was just a real bad day and that made worse. So I'm just indicating that to the court. I'm asking that she's accepted responsibility for this incident as well as a probation violation by entering into this plea at this point in time. We're asking for a personal bond as she gets ready to go for sex.
So, ma'am, you had a lot of real bad days, it appears, in this court, because your matters date back all the way to 2022. In 23, failed to display a license, allowed an unlicensed driver to drive. That was as a result of a driving while license suspended. Another driving while license suspended, plate violation, possession of paraphernalia, which is what you're currently on probation for, and now you have a high BAC.
Okay.
You're not allowed to drink alcohol on probation anyway, ma'am.
Okay.
Yet you did it anyway. We're gonna test right now what's in your system. When's the last time you consumed any alcohol?
That night.
Where do you work?
Right now, I just got a new job at it's called Baker's Life. It's a life insurance agency.
Well, given the fact that you're on probation for possession of paraphernalia, and you've completely disregarded the conditions and orders of this court for probation purposes, the court has concerns that you're going to disregard its orders of bond. To ensure that you're not going to do that, the court's going to order a $5,000 10% bond. You're not to possess or consume any alcohol or drugs unless prescribed, which you're already not allowed to do because you're on probation. And then you are not to be released without an alcohol tethered through the Wayne County Jail.
Your Honor, can she, if you're able to post it, make arrangements rather than going to Wayne County Jail to obtain the tether
Yeah.
here, if that can be posted. Instead of through the Wayne County Jail, the tether.
There's no talking in court. If you want to have a conversation, go out into the lobby, sir. No, your client's being taken into custody. She's not going to be released until she has the Wayne County Jail alcohol tether.
Thank you, Your Honor.
So you're going through this door today, ma'am. You want to have a conversation with your work that you won't be there.
When she's released, you then step two. Okay. Let's start the police today.
Okay, ma'am, you can step out into the lobby because you and your person next to you continue to talk. That's why you're out in the lobby. Counsel, I indicated that your client's taking the ride down to Wayne County Jail to get the tether.
I understand, Your Honor.
Yes.
And then when she's released on the tether, she will then have to appear for.
Oh, for a PSI, yes.
What I was.
I'm sorry, I didn't understand
what you were saying about going to Wayne County. Yeah.
Yes.
Just confirming what she's to do once she.
Yes. Yes.
Okay. Thank you, Your Honor.
All right, thank you. Have a good day. Okay, let's go on the record. in the matter of the state of Michigan versus Anthony Montaloro, 25648.
John said no shots.
Okay, thank you.
Morning, Your Honor.
Good morning.
Your Honor, John Gold for P 30758 on behalf of Ed Montalero. Mr. Montalero, would you please put your name on the record?
Anthony Montaloro.
Okay, very good. Thank you. Thank you for addressing appropriately for court. Today is the date scheduled for sentencing on your client's plea to an amended charge of operating while visibly impaired. The original charge of high BAC and open alcohol were both dismissed by way of resolution between counsel. And did you have an opportunity to review the report and recommendation with your client counsel?
Yes, we have, Your Honor. As to the report, the only correction, or not correction, but I guess an addition or amendment, is that Mr. Montalero is no longer working with Cusco. He is now working full-time or more. I won't say full-time because he's still going to school and taking classes regarding finance, but he's working with his father in the landscaping and snow removal business. He was doing part of that prior to it, but now he's doing that on a more full-time basis to earn more money. Other than that, Your Honor, there are no additions, deletions, or corrections. However, he did, I guess there is an addition, he also has obtained documentation from Pure Psychiatry of Michigan. Documents were presented to Ms. Shine today regarding his use of medical marijuana, as well as his prescribed Adderall to help him with his difficulties. Other than that, Your Honor, there are no additions, deletions, or corrections to be made. We're asking that the recommendation be. I've also explained to him briefly what early is charged, early termination. Is that correct, sir?
Yes.
Okay. Stop. Sir, what is, the court did receive this morning.
That's correct, Your Honor.
What is the medical need for prescription marijuana?
This pain. I have really bad back pain. I have a problem going to sleep at night.
Interesting. Very interesting, sir. Do you know why I say very interesting?
What?
Because you've gone over your PSI with your attorney, correct?
Yes, sir.
Okay. And it says the defendant described his general health as very healthy. He reported that he has had no serious illnesses, diagnoses, or accidents in the past. Defendant is currently under a primary doctor's care, which is this primary doctor, correct?
Yes, sir.
Okay, great. So where in that does that tell me that you have bad back issues at 19?
It's not bad, Your Honor. It's not a serious problem. It's more for the sleep.
The sleep.
Yes, Your Honor.
Okay. Well, interesting, because the letter from your doctor here indicates that you've been counseled and educated on potential risks utilizing Adderall and also cannabis, one of which is the potential impact on sleep, as both substances may disrupt normal sleep patterns. Did you read this before you submitted this to the court, sir?
Yes, Your Honor.
You did. Okay. So then you're aware that this does not indicate that this doctor is prescribing it for you.
Yes, sir.
This doctor is merely indicating that he has gone over the risks and considerations associated with Adderall use and marijuana use, but that I don't have anything that says that you should be, that marijuana is the preferred course of medication for you.
Yes, sir. I went to get my medical card.
Oh, yes, sir. I'm aware of that. I see this right here. And I'm presuming when you went to get your medical card, that was not from your treating physician, correct?
No, Your Honor. It was not.
It was not. No, it was a medical marijuana clinic. You just walked right into a medical marijuana clinic, said you had pain and trouble sleeping, and there's your prescription, right?
Yes, Your Honor.
Right. Okay. Not gonna fly. Not gonna fly. especially because your treating doctor has indicated that there are potential side effects because you're taking Adderall. Did the doctor where you went for the medical marijuana clinic, does he know you take Adderall?
Yes, sir.
Okay. So, this is just indicating that all this is stating is that you're an established patient with this doctor. The doctor's aware of your current cannabis use and is discussed openly during clinical visits. And went through the education for you regarding risks and considerations with taking Adderall and cannabis. So it just indicates you've been counseled on it. Doesn't indicate that this is your doctor's recommended course of treatment. So your medical marijuana requester is denied while you're on probation. So if you were to test right now, what's in your system?
Adderall
And when's the last time you used marijuana, sir?
2 nights.
With what permission?
Hmm?
With what permission? This court on August 7th ordered you not to possess or consume any alcohol or drugs unless prescribed.
Yes, sir.
And then you were also given information that if now you wanted to get a prescription for marijuana, what the steps were. You need a court approval to now use marijuana after the court reviewed documentation from your treating physician that recommends marijuana as the preferred method of medication. That was not submitted. So you don't have permission to use marijuana, sir.
Yes, sir. I understand. I'm sorry.
And sir, you're 19. You're 19 years old. I do not see a need for marijuana for you. Neither does your doctor. Your doctor didn't prescribe it. And this is why I require it from a treating physician, so that there can't be some circumvention because somebody wants to continue to use substances under the guise of it being for medical purposes.
Yes, sir.
Especially when you're 19, sir. Let's see how you feel after you've had some clarity not using any of this substance. So I'm not going to violate your bond right now, although you did not follow this court's orders. I am going to have you test today so that we can get a baseline.
I didn't mean to interrupt the court. I believe that he thought he was following correctly by getting documentation and then going. I don't believe he did that to circumvent the court's orders, but thought he was at least.
No, and it was explained to him very much so. Just because he gets this doesn't mean that he can then use, because he's under court supervision and he has to have it approved. It was not approved, and yet he still went ahead and used it. I'm indicating I'm not going to violate your client for a bond condition, but I am going to have him tested today so we have a baseline, because I'm presuming within the next 30 days, he's going to be tested and then he's going to show positive for marijuana. So we're going to have you tested today so we have a baseline, sir.
Thank you, Your Honor.
Anything else you want the court to know, counsel?
No, Your Honor.
And sir, especially if you're doing snow plowing and whatnot, right? You can't be under the influence of anything. And even if you don't think so, if you use something at night, you still are under the influence in the morning. All right, the court's going to note, after hearing from counsel, hearing from Mr. Montaloro, reviewing the report, the recommendation, the court does find that there's reasonable grounds to depart from MCL 769.5. The court's going to order that the following sentences in the best interest of justice is reasonable proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Montaloro and the legislative guidelines. The court's going to order 18 months probation. The court's going to also indicate that you're eligible for early discharge, sir. And the court will go over that in just a few moments. Okay, let me just clarify. So it appears as though the recommendation only addressed count 1, but there's both counts that your client pled to, the open alcohol as well.
That's correct.
So I'm just going to indicate that these conditions are concurrent. Okay. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of this court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You are to notify your probation officer immediately of any change in address or employment status. Excuse me. And you are not to possess or consume any alcohol or drugs unless prescribed. You'll be subjected to random testing. The rehabilitative goal for that condition so the court can monitor your progress in maintaining abstinence and sobriety. You also are to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition, sir, so that you can have assistance in providing coping mechanisms to maintain sobriety and prevent relapse, hopefully preventing this matter from happening again. The court's going to order you to participate in the MAD Victim Impact Panel. The rehabilitative goal for that condition is to further increase your understanding of the dangers of driving under the influence and to educate you about the consequences of such behavior. And the court's going to order 7 days on the court workforce. So technically that'll be 4 days on count 1, 3 days on count 2. The rehabilitative goal for that condition is to allow you to further develop life and work skills and give back to the community. Any questions regarding any of those conditions?
No, you're.
Okay. As to the fines and costs, $300 fine, $100 screening assessment fee, supervision oversight fee of $900. That's $50 a month at 18 months. And since you're eligible for early discharge, up to half of that could be waived. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50 for a total of $1,725. As to the open alcohol, $100 fine. I'm not assessing a screening or oversight fee. I've assessed that on the first one. $200 cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50. And I do apologize. On count 1, 4 days on the court workforce is $160, and 3 days on count 2 is $120. So on count 1, it appears as though that's $1,885, and on count 2, it's $545. So the total, sir, is $2,430. You did post a bond. We can apply your bond and you can set up your payment plan through probation. As I did indicate, you're eligible for early discharge as long as all of the following have occurred. You completed all of your, you completed at least half of your original term of probation. You completed all of your probation requirements. You got at least 3 months without any violations, and all monies have been either paid in full, or you made a good faith effort in making full payment. Okay?
Thank you,
Good luck to you, sir. Please stop over at probation. Somebody will be with you shortly. And just so we're clear, the court has not granted your request to use marijuana for medical purposes at this point.
Yes. Thank you.
Thank you. City of Wyandotte versus James Holt, 251594.
Again, Your Honor, Neil DeBlois here on behalf of James Holt. Mr. Holt, can you hear us? Please state your name, sir.
James Thomas Holt.
All right, and so, Mr. DeBlois, you have requested to withdraw the request for competency evaluation on behalf of your client, correct?
That is correct, Your Honor.
And you also were the attorney that represented Mr. Holt at the arraignment on November 13th, correct?
That is correct, Your Honor.
And at the time that you represented Mr. Holt at the arraignment, you had concerns that Mr. Holt had potentially some competency issues. Is that correct?
That is correct. Yeah.
And today, after speaking with Mr. Holt, you no longer have those concerns.
I don't believe Mr. Holt is, I believe he's confident. I believe he understands, as I expressed earlier, that he's lucid. He understands the consequences of his actions, and he rationally and reasonably wishes to try to resolve this case today if possible. To say that I don't have, as far as his competency, I think he's competent.
Okay. And you also believe that on November 13th, potentially, I signed that. That potentially his competency issues or concerns may have been due to some substance that may have still been in his system.
That's quite possible. As I recall,
Okay.
he was allegedly involved in a matter at the CVS store here in Wyandotte. And when I spoke with him, just a few hours after he had been arrested and held in custody, he was, as I say, scattered, disjointed, and understandably, I think somewhat confused.
If I may say, earlier before that, I had gotten robbed. My phone was taken from me. I just wanted to shed some light as to why I was a little bit scattered.
Thank you.
Okay, thank you. We're going to get to you in just one moment, but thank you very much for interjecting that. Okay, the court will grant the request to withdraw the competency evaluation. So Ally, I don't know what we have to do on our end to notify CFP, but we'll have to do something, I'm sure, but. Okay, and so then counsel, you want to proceed with the pretrial, correct?
Yes, sir. I've had a chance to review this with Mr. Holt, and I believe he made a rational, he rationally understands what he's facing to the attorney, and the discharge one count of trespass.
Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
And sir, you heard the plea that was placed on the record, correct?
I believe so, yes.
Well, your charge is trespassing, and that appears to be pleading to, correct?
Could you say that again? I'm sorry, the mic kind of cut out.
Trespassing is what it says that you're going to be pleading guilty to, what you're charged with.
Yes.
All right. And so as to that charge, sir, how do you plead? Guilty or not guilty?
Guilty.
You've also gone over your rights with your attorney, correct?
Yes, Your Honor.
And you understand all of those rights.
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes.
Excuse me. You also understand, sir, the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, Your Honor.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
Any immigration issues?
No, Your Honor.
All right. And counsel, if you can please ready your client.
Well, Mr. Holt, you recall being in the city of Wyandotte around the 12th of November.
Yes.
And you found yourself in a CVS, a private business. Is that correct?
Yes.
And at some point, the employees of CVS had asked you to leave the store. Is that correct?
No, actually, I had asked somebody to call the hospital, and the police ended up showing up and I got arrested.
So,
well, if you're confused, I'm confused.
as I understand it, well, let me say this. The police report states that you were lying on the floor in the CVS. Do you recall that?
Yes, I do. I recall that.
Okay. And is that normal behavior in a CVS?
No, I was just scared because I got robbed. I swear, like that's like
And so did the employee object to your conduct there?
Could you repeat that?
So did the employees object to your conduct there, laying on the floor of the CVS?
Well, they called for me and they tried to get an ambulance.
Apparently they called the police. Do you acknowledge they didn't want you there?
Do I acknowledge what? I'm sorry.
I said, do you acknowledge that they didn't want you there? They called the police, not an ambulance, because the police are out.
I didn't realize because the way that they called made it sound like they were calling an ambulance for me, so.
Mr. DeBoy, would you like a breakout room with your client again?
Yes,
Okay. All right, the court's not going to accept the plea at this point. We'll recall this matter.
Thank
you. Thank you. I don't know if he needs a police report to review that. So. We're on the record. We're recalling the matter of James Holt, 251594.
Ready, article, we have James Holt, the Holt station name, sir?
James Thomas Holt.
Thank you.
Okay, thank you. Okay, and so counsel?
Yeah, proceed with the, what they're.
All right, and so, we've established everything except the factual basis. So counsel?
Yes, Your Honor. Mr. Holt, you do recall being in the CVS, pharmacy in Wyandotte on about the 12th of this month, correct?
Yes, sir.
And, you've already testified that at some point the, police removed you from the store, correct?
They removed me, yes.
And do you admit that prior to that date, somewhere on October 21st, CVS had trespassed you, meaning that you had been there and they ordered that you not return to their premises, that be sometimes known as being trespassed. You do admit that, you do recall that.
Yes, sir.
So you knew that you were not supposed to be there on November 12th, but you went in there in spite of that. Is that correct?
Yeah, admittedly, it was a bit of like a lapse in judgment because I had gotten robbed like earlier that day, like I said, with my phone and stuff. Like it was an honest like mistake. I just want to
Again, just for clarity, you were trespassed from the store. They advised you, they required you not to return, and you knew that. Is that correct?
Yes, sir.
You're unsatisfied. Thanks.
All right, the court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the charge and counsel.
You're asking for these, and Mr. Holt been in custody of the Wayne County prison jail system since the 12th of November. Today is now the 26th, I do believe. In any event, it's been there for 2 weeks. This is an extremely minor incident. Mr. Holt does have some mitigating circumstance that the court now is aware of that. He wasn't going in there to hurt anybody. He was looking for assistance for himself. He admitted that he did not have permission to be there, that he may have caused somewhat of a scene, but he didn't hurt anybody, he didn't try to steal anything, he didn't threaten anybody, nothing like that. That's well not to say the challenge since keeping him in jail any longer is to my mind, exacerbate his problems and to nobody's benefit. I ask court to simply sentence him to the time that he's already served, and due to his financial situation, the court will consider waiving fines and costs as well.
May I just say one thing? I just wanted to say to the judge, like, if you just like give me this one chance, I'm not gonna come back to I'm not gonna be back in court for like anything I'll make this my last time. If you can hear me out on that, that's all I wanted to say, Your Honor.
Okay. Sir, I recall in the police report something about you thought you were at the hospital at St. Mary's in Livonia. That seems to be a little bit of a bit of a distance from where you're at.
I had requested to go there. Yeah, I requested to go there when they showed up. I didn't think that I was there. I don't know if that's what you said.
No, I didn't say it was it's not what I said. I was just wondering if you what that all entailed. And if you thought you were there or whatnot. So okay.
Yeah, I was just in a bit of a panic because like I got robbed, like I said.
And so did you make a police report about that at any point, sir?
Did I?
Yes.
No.
Okay. All right. And so, sir, prior to this, were you working?
No, I've been out of work for a while. I have a few friends that I'm trying to get with to be able to start some work. Last summer I worked with my dad. I was living with him, so that's the last time I was technically working.
Okay, and so where do you work otherwise? Or where do you live otherwise?
I'm currently homeless, but I have a few friends that'll be able to help me out. So that's my plan at least.
And do you have any other pending matters, sir?
No, not that I know of, no.
What about your matter in Plymouth from October?
I received some mail for a payment plan. So I'm gonna stay on top of that.
Well, if you're not working, how are you going to pay, sir?
Well, I'd already discussed with them that that we were gonna work out a payment plan, and they sent me a piece of mail. I haven't had the opportunity to open this piece of mail yet, but I was gonna go from there and be able to get a job set up pretty soon, but I can't really do that while I'm here. But like I said, I have a few friends that'll be able to get me started pretty quickly.
Yeah.
Okay, so, sir, here's what I'm going to say. So where do those friends reside?
Lincoln Park area?
Not in Wyandotte, correct?
No, not Wyandotte.
Good. The court's going to order 15 days jail, credit for 15 days. You're not to return to the city of Wyandotte.
The whole city?
That's correct, sir.
Okay. But one thing about that, I have property in the Wyandotte police department though.
Well, with the exception of that.
Okay. Thank you.
Have a good day. I'll suspend fines and costs.
Thank you, Your Honor.
Thank you.
Is Mr. Wright there? Hello, Your Honor.
Are you Xavier Wright?
Oh, little beard. Yes, sir. I'm sorry how I look. Let me get myself together.
That's all right. I don't look my best either sometimes. Mr. Wright.
No, you do. I see that beard on you. That's cool. Mustache.
Mr. Wright, I'm Harris Blanchett. I'm the justice of the peace. You are charged with the offense of possession of marijuana, a class A misdemeanor. You had an amount that was less than or equal to 4 ounces, but greater than 2 ounces. Do you understand the charge?
No, well, can I say that it was less than 2 ounces?
I can say that this is what you're charged with. I don't. Okay. I'm just here to tell you what you're charged with.
Okay.
I'm asking if you did it or not.
Okay. Thank you.
All right. Well, you have the right to hire an attorney to represent you. You have the right to have the attorney with you while you're being questioned by peace officers or attorneys that represent the state. You have the right to remain silent. You're not required to make a statement, but any statement you make can be used in court against you. And you have the right to stop making any statement or interview at any time. Do you understand those rights?
Yes, Your Honor.
All right. And do you need a court-appointed attorney or you're going to get your own?
I want to represent myself if that's possible.
Yes, sir. Are you a citizen of the United States?
At the moment, yes, Your Honor.
At the moment, you think you might lose that citizenship?
Well, I was actually headed down to the United Nations to get my foreign citizenship.
Why, you are a citizen then, right?
Correct. At the moment, yes. That's why I stated that.
Are you currently out on bond for any other charges anywhere else?
No, Your Honor.
All right, and your bond has been set at $5,000.
Goodness.
You have any questions I can help you with today?
So I was traveling through the states. So I was traveling through you all. As far as a bail bondsman, if I did do a bail bondsman to pay that, how would I go about it with court? Because I'm not from here.
You'll just call a bail bondsman, have him post your bond, and you'll get out. Then when you come to court, when you get your court comes up, the bondsman will call and let you know when and where your court is, and then your obligation to show up.
Can I do it all over Zoom since I don't live here?
I do not know if you can or not. You can ask the court of that. I'm not going to be the judge of that court.
Okay.
You might be able to.
I'm sorry. Can you say it again, sir?
Any other questions?
The last part. Yes. How would I get in contact with a bail bondsman?
The jail staff has the phone numbers for the local bondsmen that are across the street.
Okay, and it's 10%, correct?
You can, I don't know what they charge. I've never had to make a bond. So, but yeah, you can call and talk to them and ask them what they charge and see what they do.
Okay. Thank you again, Your Honor.
Thank you.
143 all the way, please. 143 all the way.
Your Honor. Quick question. Can you hear me?
Yes, sir.
Could I have my bond lowered?
Not at this time. We'd have to have, you would have to represent your court and have a bond hearing, and you would have to do that at another time. You can't do that today.
I don't know how much you have on the card. It's 10%, 10% of $5,000.